Good morning, everyone. My name is Apurva Sharma. I'm the founder and the principal solicitor at GPS Lawyers and Consultants. Welcome to the second of our information series on student visas and visa cancellations in general. We have with us Mr. Harry Grossman, our senior consultant and immigration specialist. Welcome, Harry.
Thank you, Apurva.
We'll be talking about NOICC, which is Notice of Intention to Consider Cancellation. We'll straight delve into it, Harry. So let's start simple. What exactly is a NOICC, and when does a visa holder typically receive one?
Excellent question. Well, a NOICC, of course, is an acronym for a Notice of Intention to Consider Cancellation of a Visa. By that we mean that the department has received information or has reason to suspect that the visa that a person holds needs to be cancelled for one of a variety of reasons. Most typically because the circumstances of a visa holder may have changed and therefore that visa is no longer appropriate, or alternatively because there has been information received by the Department of Home Affairs, the Immigration Department, that false information or misleading information, or for that matter bogus documents, were provided to the department and formed part of the basis for the receipt of that visa in the first place.
Would you say those are some common reasons why NOICCs are issued in your experience?
Most definitely. We come across, unfortunately quite too often, false documents or information that have been provided in support of a visa application, or circumstances, for example, of a failure to meet a visa condition, such as in a student visa, the failure to meet course requirements and satisfy those on an ongoing basis, or in the case of a work visa, work-related visa, when the visa holder is no longer working for that employer.
If the NOICC is issued, what, in your opinion, are the immediate steps a visa holder should take upon receiving a NOICC?
I understand, of course, that a NOICC is a deeply distressing document to receive. It's a letter from the department which in effect indicates that the visa holder's visa is now under scrutiny and may well be cancelled. It's terribly important on receiving a NOICC that the visa holder carefully reads the content of that letter. The letter will contain several sections which include a description of the information which the department has received, and also, of course, the reasons why the department considers that appropriate to consider cancellation, the timelines for response, and the implication on a visa holder for failing to respond.
What kind of evidence or submissions make a difference in responding to a NOICC?
Clearly, after carefully reading the material contained in the NOICC, and especially, of course, the so-called evidence upon which that NOICC is based, it is important for the visa holder to write down a list of any allegations that have been made, and indeed to prepare themselves for response to such allegations. It may be quite simply that the department has obtained incorrect information, may it be from the course provider, the education provider, mistaking the identity of one student with another. But obviously, once that information has been noted, it's terribly important for the visa holder to act within the timeframes indicated by the NOICC.
Thank you, Harry.
Certainly.
How does Section 501 come into play here?
Yes, the minister may consider cancellation of a visa if the visa holder's circumstances are such that the minister considers that that person is not of good character. And character is assessed in a number of ways, particularly if it comes to the minister's attention that the person has received a conviction or convictions resulting in a term or terms of imprisonment, whether actually sat, of at least 12 months. But the minister can also consider one's general character, and there is a scope for determining under the relevant ministerial direction that a person is not of good character, and therefore that person's visa warrants cancellation.
Now, talking about other substantive grounds, how often do NOICs arise from academic issues like breaches of student visa conditions?
Very, very frequently. And indeed, allied with that, unfortunately, is the problem of false or misleading information. And sometimes that can arise after a student has obtained multiple student visas, always based on the same underpinning false or misleading information.
Do you think that there is an increase in NOICs related to the false and misleading information?
Yes, indeed. It's come to our attention in particular, Apurva, that there is a whole cohort of persons who have in the past received work and holiday maker visas, and indeed have applied for further work and holiday maker visas on the basis that they have worked for a minimum of 3 months in regional areas. The department is now making routine checks of the documentation supplied by visa holders and visa applicants in support of those further holiday and work visas, and has discovered, unfortunately, in a huge cohort of cases, that the payslips and other relevant information are indeed bogus documents. And this can come about very easily when the department contacts the purported employer that has granted the alleged employment in the countryside, only to find out that there is no record of the visa holder or visa applicant ever having worked.
Could you share a case where a strong response to a NOIC led to a successful outcome?
Most certainly.
And I'm talking about either at the department level or at the AAT, now ART.
Well, let me share with you a recent case that came through our office. And that case concerned the secondary visa holder in relation to a 485 visa, temporary work visa. In that particular case, and this is classic of those NOICs that are issued where there is a relationship breakdown, the spouse found herself receiving a NOIC because the former husband had informed the department of the relationship breakdown. Here, as you can well imagine, you've got a situation where the secondary visa holder has become subject to a NOIC for circumstances that are clearly beyond her control. What is the correct approach in that situation? Obviously, as we mentioned fleetingly before, there are timelines, there are deadlines for response in relation to NOICs. They can vary depending on the circumstances of the alleged situation, between 5 days and 28 days. Typically, a period of 14 days are granted, but irrespective of the time frame, it is terribly important for a response, an educated response, to be delivered to the department within the time frame. I might just add tangentially that these timeframes cannot be automatically extended by the delegate, by the officer in charge of the case at the department. However, a request can be made for an extension of time within which to respond, and depending on the circumstance, it could be anything from 5 days to a further 28 or a full 28 days. But in addition to making that request for an extension of time, it's important to address all the reasons why, in our example of the secondary visa holder, why it is that that person should not have their visa cancelled. Here are a list of some of the factors which we drew to the department's attention.
Sure.
Firstly, the length of time that the secondary visa holder had been in Australia. Secondly, the fact that the visa holder had never breached any of her visa conditions in the past. Thirdly, that the relationship had broken down because of family violence, and it is the policy of the department not to penalise visa holders in those circumstances. Furthermore, that there are children born in Australia who have been partially educated here and of course have never seen an overseas country. That the visa holder has made contributions to Australian society. And those submissions should be supported by documentary evidence, of course.
Sure.
And the documentary evidence will include a statement from the visa holder herself, supporting statements by persons of good repute, evidence, if relevant, of medical conditions and why it is that we say that those medical conditions cannot be properly treated in the home country of the visa holder, and any other supporting documentation that will be relevant, obviously, in the circumstances.
Thank you so much for that information, Harry. That's quite an important information for those who have either been served NOICC or are under similar circumstances. Now, if someone had to prepare a statement in support, would you say that the documents that you just listed are some of the 3 most important documents that they must cover, or what are those things in general that they must cover?
After very carefully reading the grounds for the possibility of a visa cancellation that are contained in the NOICC, and after making notes of any allegations, it will be important for the visa holder to respond to those specific allegations and to support those responses with relevant documentation. For example, if it is alleged that the student did not attend sufficiently in relation to their course, it's important for the visa holder to contact the education provider and make sure there has been no error. For example, a simple error might be 2 students with the same surname Singh, one of whom attended, the other didn't, and the department rang and the junior officer at the registry gave incorrect information. So if there is supporting documentation from the school that indicates that an error had been made, this is important to draw to the attention of the department. It's also important to consider the NOICC very carefully, and this is where an accredited specialist in immigration law, as our firm has in myself, or for that matter a very experienced registered migration agent, can examine the NOICC and determine whether or not on its face it even warrants visa cancellation. Let me give some examples.
Sure, Harry.
The first of these might be that the time frame for response exceeds the time left on the actual visa. Or secondly, the information gleaned by the officer is really quite insufficient to warrant visa cancellation, or there are lines of inquiry which one can request the officer to undertake, which would be appropriate reason for the NOICC to be withdrawn. All of those are matters that really a qualified professional can assist the visa holder.
What's one piece of advice that you'd give to someone listening who's just received a NOICC today?
First and foremost, although there are deadlines for response, that does not warrant knee-jerk responses which may serve to unfortunately undermine what might otherwise be a strong case against visa cancellation. A word of caution, it is terribly important, because NOICCs are complex documents, to seek proper advice before responding, and as a result of that advice, have carefully tailored and nuanced responses rather than knee-jerk responses.
Thank you, Harry. For advice on NOICCs and for submission work on NOICCs and to represent you, you can reach out to us on the number and the information given on the screen. We will come back with more information on visa cancellations in general and focusing on student visas in our next information series. Thank you.
Thank you.
Thank you, Harry.